I'm working on a file, and either I'm working for the employer or the employee, and we're trying to reach some sort of resolution. And in some cases, the refusal to provide a reference becomes an impediment to settlement. I like that expression. I'm going to have to use that more often. But that becomes the last issue. We've resolved all the other ones, all the money, which is usually the biggest one. And now we can't get past this. And what baffles me, and people want references when they're hiring, and yet for some reason they won't give them when they're not hiring, which doesn't make any sense to me. And what I will say is this: the whole no references policy as a blanket policy doesn't make any sense to me. There are certainly situations where you're not going to want to give a reference, and that's fine. But as an overall policy, it doesn't make sense. And this is one area where I think HR and employment lawyers are not on the same page. My team and I work with HR day in and day out. And for the most part, it's a pretty symbiotic relationship. We tend to see things the same way. We tend to be aligned as against others in organizations. In this case, though, it's quite remarkable. And it was about 3 or 4 years ago. Some viewers may know I'm the founding director of a course called HR Law for HR Professionals offered by Osgood. And it was about 3 or 4 years ago. We had a panel of employment lawyers. At the end of the day, we had an open Q&A session. The issue of references came up, and we had 4 lawyers, myself included, up at the front saying, there's no reason to have a no reference policy. Give references in most cases, except where there's good reason. And we had a room full of about 35 or 40 HR people, all of whom were sitting there shaking their heads at us. And they all said, we don't, we can't, we won't. And it just seems to be getting worse and worse in terms of this disconnect. Everybody wants a reference when they're hiring. So why would you not give them? Second of all, if you're talking about a situation where someone's been in your company for 20 years and they're let go because of a downsizing or restructuring, nothing to do with them personally, no fault of their own, why would you not give them a reference to help them find new work? So that's the practical aspect and perhaps the ethical aspect. From a legal aspect, there is no reason for this widespread fear that we have. I know that a lot of it is driven from the US, where they are far more litigious than we are. I get that. And I understand that when it comes to making negative comments, people are pretty skittish. I can understand why most of us have been brought up to say, if you can't say anything nice, don't say anything at all. We've all been told that. We've all seen the multi-million-dollar defamation claims, again, largely out of the States. So people are scared to make a negative comment. What I can tell you is this: if you make a negative comment in the context of a reference check, if you are honest, if you act in good faith, you will not be exposed to liability. And this has been the case for many, many years. And there was a decision out of the Ontario courts last year which confirmed it. The case was Papp and Stokes, where a reference check was done and the responding employer gave a negative reference and they were sued for defamation. And the judge clearly agreed that the comments were defamatory in the sense that they were negative and gave a negative impression about the individual. And they were publicized, i.e. communicated to more than one person. But in their defense, what the employer said was, A, it was true, and B, because we were giving a reference, we have a qualified privilege. And what that means is that as long as you're acting honestly and in good faith, you will not have or not be found to be liable for the comments you make. And no liability was found in that case, which I think is really important. A lot of people assume that they cannot say anything negative in today's day and age. That's not the case. But be honest about it. Don't stretch the truth. Don't make things up. And I've seen this happen where somebody was fired for a breach of a policy and they applied for another job, and the potential employer called the former employer to find out what happened. And the former employer, for reasons only they will be aware of, lied and said that they engaged in theft. So, of course, the person wasn't hired. Don't do that. Be honest, act in good faith, but also tell the truth. There's no reason not to. So that's for a negative reference. What I really want to talk about is positive references, because let's keep it in perspective. The vast majority of terminations in Canada are without cause. They're often restructuring, reorganization, downsizing. It's not because of the person, it's because of external factors. And yet employers have this policy where they will not give references. They will only give a confirmation of employment, the name, rank, and serial number, as I often call it. No good reason. And I've asked countless people, why? Why would you be scared? And the explanation I've been given, and I'm happy if anybody else has a better one, feel free to email me or send it to me in any of the ways we've talked about. But the explanation I've been given is that they're scared that if they give a positive reference and the potential employer relies upon that, hires the individual, and the individual turns out to be a dud, or even worse, engages in theft or other misconduct, that employer is going to turn around and sue them for misrepresentation. So I can tell you, when this was first explained to me about 5 or 6 years ago now, I had a student do the research. There was not one successful claim on that basis in Canada. I admit I haven't done the research lately, but I'd be shocked if there has been one since then. There is no reason to be concerned that you'll be sued successfully for a positive references. So keep that in mind. Keep in mind that when you're hiring, you want the references, so you should be giving them. And keep in mind one other thing too. You have a motivation as the former employer to help your former employee find new work. As most people will know, people who have lost their job have a duty to mitigate their damages, i.e., make reasonable efforts to find new work. If they find new work, their entitlement to severance is going to be reduced. So you have an opportunity here to cut your severance costs, help them find new work, give them references, consider outplacement counseling. And also, when you're going to give the severance package, consider a package that is based upon salary and benefit continuance with a clawback. A clawback is if they find new work, their entitlement is reduced or eliminated altogether. Now you've got all the motivation you need to help them find new work. So I'll really encourage everyone, reconsider the no references policy, scrap the policy, and just take every situation on its own individual merits. If there's a good reason not to give references, so be it. But in the vast majority of cases, there won't be a good reason. So there's my 2 cents worth. You got it here for free today. Thank you very much, everyone, for tuning in.